The only thing we have now is State versus Sanders, and you're both here for that, I see. And the only thing I would say is, I'm not sure that it even matters in this case, but we'll still say it, that we don't mention the names of victims, and we don't mention the names of children. Mr. Gucci, if you would let me know how many minutes you want to reserve. Obviously, you have 15 minutes total for both of, both of you, each of you has that. And the court has read the briefs and ready to proceed.
Thank you. Good morning, Your Honors. May it please the court. I am Richard Kudachief. I am court-appointed counsel for Maxine Sanders. And the first thing I want to say, it is an absolute joy and privilege to be back in front of this court in live. It's been a long time, and I'm happy to be here.
Well, we're happy to have everybody.
Thank you, Your Honor. Judge Carr, I would like to reserve 2.5 minutes.
Okay, that's fine.
It's okay. So, Maxine Sanders, some might say, Richard, what do you hear in this very honorable judicial district to argue for Maxine, who has all these prior misdemeanors, solicitation? You know, she had drugs. Why are you here to argue for Maxine in this honorable court? And the reason for that is the big picture of what's going on in this world relative to drug addiction. And Maxine has her issues, she has her problems, but why shouldn't she be an intervention so she doesn't have a felony? Discretion. The court has discretion. So the state's posture to me is confusion there. It's confusing to me in the sense, what governmental interest does the state have here in arguing to keep people out of intervention? Here, to achieve this end, the state has the basis of its persuasion that Maxine shouldn't get intervention because the statute doesn't apply retroactively. It's not a retroactive statute. To me, that is not the foundation of the appeal. Certainly, as the state pointed out, I did not raise that. Indeed, it's the state's position that they're looking at the prospective application, not the retrospective application. I think that's what they pointed out in their brief. And that's my concern as well. The prospective application of the intervention statute. Strict treatment doesn't seem to be the state's concern, and addiction doesn't seem to be the state's concern. The individual here does not seem to be the state's concern. Eligibility doesn't seem to be the state's concern. There's no question in this record that Maxine Sanders is eligible for intervention. There is nothing in this record that shows that she is not. Now,
Counsel, in regard to that, I'm sorry.
You beat me.
Go ahead. In regard to that, whether you're looking at either statute, the trial court in its entry said that she is not eligible. So are you contesting, are you arguing that she, you're saying she is eligible and nobody's really contesting that? But the trial court seems to be, is what I'm trying to say.
well, Judge, thank you for that point, because it is a strong one. Exactly what the court ruled in their definition, saying Maxine is not eligible based on her many misdemeanor convictions. That's not the statute yesterday or today. That's not the purpose at all.
Counsel, in that same regard, you said there's nothing in the record that shows she's not eligible. What do we have in the record that shows that she is eligible?
Also, good point, Your Honor. Thank you for that. And what we have is, in my application, my request for intervention, I lay out uncontrovertibly, by the way, from the government, that she has this, and this, and that she is therefore eligible as a result of all those statutory. And that is a very strong point, because the state has raised that issue that the appellant has not shown eligibility, but it's clear in the record the state has not shown ineligibility, and that's very critical here.
Was she assessed?
No, Your Honor, and partially as we are here for today, because the court did not give her the right to assessment. So let's say that as Attorney Corrigan may raise here, well, the judge has discretion to not give an assessment. And even if we concede to that, I get back to the issue of abuse of discretion. Look, these are all prior misdemeanors. There's no felonies that can be shown. There's no disqualifying point or conviction that Maxine has. So on March 30th, 21, she was indicted for a 5th-degree felony possession of cocaine. Now, what does possession of cocaine mean? It means she's a drug user. It means that she's not only a drug user, but an illegal drug user. Most specifically, that's precisely why the request for intervention is made, to assert the statutory grounds and demonstrate the eligibility, as I said, uncontroverted in the record. So on September 8th, we have a hearing on this request, and here's what the court ruled in the judgment entry. Upon review of the defendant's extensive prior record, the court finds she is not eligible for said program. And I'll just digress for a moment. Intervention in lieu of conviction is not a program. What I call it is a statutory diversion. And what's significant about that, it is a treatment plan. So if my client has money, if we have money, we can go to Betty Ford, the Betty Ford Clinic in Rancho Ridge, California, or Seasons in Malibu, or Glen Bay, not far from here, or IVH in Coventry Township, by the way. But when you don't have money, then you're referred to the probation department, and you go to a program in our county where folks who don't have money, who are indigent, can have treatment. Because what it is, it starts with eligibility, but what it ends with is an intervention plan. And that's critical. That's critical. Take a look, if you will, and please look at, as you read my brief, look at what's going on in this world. We hear it daily. Those of us in the trenches, if you will, at the trial level, deal with it daily. I deal with addiction every day. Folks who are doing fentanyl, meth, these drugs are of such extraordinary impact on our society, not to mention the individual. So what are we looking for? So Maxine was indicted. The state will say no retroactivity. She's indicted on March 21st, 2021. 3 weeks later, the General Assembly then passes, or is now into law, that the new statute controls. So what reasoning is there that the old statute controls?
Counsel, maybe you can help me with this. Is it accurate that under the new version of the statute that the court still has discretion in granting or denying intervention, even though there's a presumption?
I would answer that in the negative, Your Honor, and I'll tell you why. Because of the conceptual makeup that's going on, and the trends, not only in alternate sentencing over the past 10 years, but the trends in treatment, that the presumptive requirement is if a person is eligible, and if a person is given assessment and found to be drug dependent, or that criminal activity led to the offense, then the presumption is that intervention should be granted unless the court can identify specific reasons that intervention should not be granted. So I would argue, and it is my position, that no, it is not discretionary in the sense that if the steps are there, if a person is eligible, if a person has a treatment plan, that it is presumptive, absent statement or particular definition from the court reasoning behind not granting intervention unless that is given by the trial court.
So just to make sure I'm understanding your argument correctly, so you're suggesting or arguing that there is some limited discretion?
Well, that's a good way to put it, Judge Sutton. I think when we talk about abuse of discretion, then we get back, circling back again. What governmental interest is there in arguing retrospective application that a person shouldn't get intervention? Why? And so when we talk about not granting intervention, isn't it really a theoretically, if not actually, an abuse of discretion to not give someone the opportunity? The state wants the precedent that retroactivity is going to apply. Now, I don't know how prolific that's going to be in the big picture, but why would this court set a precedent here? Because the state has also argued, well, she's charged and before, a few weeks before the statute, so when it gets down to it, to trial or to procedural, that she needs to go under the old statute. I say no, the law is more clear that you will have the right of the old statute at the time of trial, or at the time of procedure in this case. So even though the state is saying, well, it has to do with retroactivity, when it boils down to it, the state is saying the same thing. It's an abuse of discretion issue, and that is absolutely.
Counsel, just before you move on, in this case, didn't the trial court, though, actually state that so the court feels the excessive prior record is sufficient to overcome the presumption of ILC?
No, Your Honor, because the law does not provide for that. There is nothing in the law that prohibits a person with misdemeanor convictions to have the ability to do intervention. And here's what I'll develop.
Counsel, hang on a second. Her question was, didn't the court say that? The court said that, correct?
The court did say that she was ineligible.
And your argument is basically the court relied on something that is, there is no limitation on misdemeanors in statute.
That is correct. So that actual decision was erroneous, and that's certainly part of the area that I raised. And such that also amounts to abuse of discretion. Now, here's one of the things that I think the court needs to look at as well. The purpose of intervention is to get people clean. It offers motivation. It offers where you don't have a felony record. We all know the ramifications of having a felony record. So in State v. Schoaf, I quoted in my brief, the General Assembly has made the determination realistically that when chemical abuse is the cause of the crime, it's more beneficial to the individual defendant, the community, society as a whole to treat the cause, rather than punish the crime. And that type of thinking is what's most critical in an intervention. The opportunity to receive help without ramification of a felony conviction, and that comes from State v. Maxine, which the state itself cited.
Counsel, you're at your rebuttal time now.
What's that?
You're at your rebuttal time. You can keep going, or you can.
Okay. Well, let me just conclude by one thing at this point, Your Honor, and you can, yes, I'll take that off. Here's the greatest distinction that I asked the court to also learn. What is the substantive issue when it comes to the substantive nature of the crime versus the remedial issue? And I will reply to that because I think maybe the state would bring that up. All right, thank you, Your Honor.
Thank you. Good morning. You have your 15 minutes. You may proceed.
Thank you, Your Honor. Good morning, and may it please the court. I'm Jacqueline Corrigan on behalf of the state of Ohio, the appellee in this matter, which right off the top I will remind the court that the state at the trial court level did not take any position on whether this defendant should or should not be entered into the ILC program. Took no position on whether she was appropriate for ILC. The state stood silent. The reason that the state is even here in this appeal is because essentially the state's only argument is this, that because this defendant has assumed that changes to the ILC statute should have applied retroactively to her case, the state is here to posit or to pose this question to the court. Do the amendments to the statute, which took effect on April 12th, 2021, do those amendments apply to someone like Ms. Sanders? So she was indicted prior to the amendments taking effect, such that the changes to the statute would apply to her. And the changes to the statute only really come in two ways. First, it creates a presumption that ILC should be granted. And also, if the trial court decides that the presumption is overcome by whatever factors the trial court is looking at, then the trial court, in denying ILC after a hearing, has to make specific findings in a written order in order to deny ILC. Getting to some of the questions that the court has raised, Judge Sutton, the presumption does not swallow up the trial court's discretion. ILC is not an automatic thing under the statutes. The trial court still has discretion to, and I would disagree with counsel that that discretion is limited. It's only limited by the presumption itself. However, the trial court yet has discretion to find that the presumption has been overcome on a defendant-by-defendant basis. And specific to your question, at page 9 of the transcript of the hearing that took place in the trial court in this case, the trial court says, so, and I quote, "So the court feels that excessive prior record is sufficient to overcome the presumption for IILC, which is basically geared toward relatively new offenders, so I'm going to deny your motion."
Counsel, where in the statute does it say it's for relatively new offenders? It's kind of olden days, isn't it?
It is in the olden days, as you put it. The statute actually does not say anything about new offenders or misdemeanor offenders.
And where in the statute does it say anything about number of misdemeanor offenses? 1 prior, 10 priors, 20 priors? Does the statute make someone ineligible because of that? I mean, obviously, we're not talking about OVIs and something that would make them ineligible. The statute doesn't speak to that anymore, does it? Either of the two we're discussing here.
Neither of the two that we're discussing here actually has any kind of, let's count up the offenses provision and doesn't address misdemeanor offenders. Both of them say that someone can be ineligible for IILC if they have certain felony convictions. And that has not changed. So the actual eligibility qualifications have not really changed from previous version of the statute that was in effect when Ms. Sanders was indicted versus the version that went into effect in April of '21.
But the trial court found her ineligible because of the number. Isn't there a difference of, because of this lengthy record or number of offenses, I find a person ineligible, versus I've looked at this lengthy record and each time the person has not completed community control, has violated probation, has absconded? Aren't those two different things in an evaluation from the judge in terms of eligibility?
I will say to Your Honor that, and to the court, that the order that was issued by the trial court is not the model of what you would expect. You know, when a court is told in the statute, if you find that the presumption has been overcome, you will give your reasons why the presumption has been overcome with particularity in your written order. The state's argument in this is, when does that requirement go into effect?
Counsel, and I know I'm interrupting, but I think we're getting off maybe what she's talking about, because I think Judge Callahan is referring to the fact, no matter which statute is in effect, you know, the court is saying, at least in its entry, I find this person ineligible, and there's nothing in the statute, either one, that says you're ineligible based on number of misdemeanors.
That's if I could add on to that, even if we go beyond the entry to what's in the transcript of what the court said, still relying on number of offenses.
That is correct. And that's why my argument is very narrow. Once again, the state is not really taking a position on whether ILC was appropriate for this defendant. It's when does the statutory presumption come into effect for other defendants, and when does that requirement of making particularized findings that the presumption has been overcome, when does that go into effect? So when do those two changes for other offenders, when do those two changes actually go into effect? Because we may still have defendants who may be seeking ILC, because of the length of time that it's taken for people to go through the system given the pandemic and the delays that that's created. So, and also some clarification on how retroactivity will be considered, because we did submit the State versus Brooks, which is a supplemental authority. It is the latest out of the Ohio Supreme Court concerning retroactivity. Granted, it applies to hold that defendants who face trial for murder, that the burden of the state to disprove self-defense applied to their trials, even though they had been their conduct had been committed prior to the burden-shifting statute going into effect.
But in that case, the statute itself said at time of trial,
Correct.
so we don't have anything like that here.
No, and there's nothing in the statute, in this version of the statute, that would indicate that it should operate relative to offenders who were indicted prior to the statute prior to the amendments going into effect. But the way Brooks is postured and the way this case was postured, the assumption that just because someone is proceeding in their case at a time when an amendment to a statute goes into effect, one cannot assume that the changes to that statute will operate in that person's case.
Let me ask you another question. Why is the court determined that the trial court, as a matter of law, was incorrect because under either statute, there was nothing to prevent her from being assessed and receiving treatment in lieu of conviction? What is the state's response to that? Why do we have to get to the retroactivity then?
You would only have to get to the retroactivity if you were to find that. Because if the court finds that under either version of the statute, the trial court erred, then the retroactivity question would essentially be moot.
Thank you.
So, again, the state's only concern in this is, does the new version apply? If this court does not find that the trial court erred in issuing the order it did, under either version of the statute, which version of the statute actually applied? And I know it seems like from the puzzled expressions on your Honor's faces, it seems like I'm starting to turn in a circle.
Counsel, I'm going to ask you a different question. I asked this to Mr. Kukic. I know you made reference in your brief to the fact that basically we don't have some things in the record, and of course we do have some things in the record, but I have thought that there was something in the record about Ms. Saunders being referred to Greenleaf. And I recognize that you're picking this up on the appellate level, and then sometimes doesn't quite give you the familiarity. But was an assessment done in your understanding? I know something was done for Turning Point. I didn't know if it was 2 and 1 or how they did that, or if you even know.
I don't have the particular information about Greenleaf. All I really have is the information about Turning Point, where they assessed her and they determined for a reason unrelated, basically it was a reason I guess related to some other medical condition that she had, that it probably wouldn't be appropriate to enter her into the court's Turning Point program. Then the question of, is she eligible for ILC arose, and that's my understanding of it. And as far as the rest of the record is concerned, we really don't have the Turning Point evaluation in the record. We don't have anything else to say why the trial court would have abused its discretion in finding that ILC was inappropriate. Not that she was ineligible, but ILC would have been inappropriate. The entry, I know, says that the court found her ineligible. The state has to live with that language. However, my reading of that entry, and also I will say that there was a non-pro-tunc entry made that had more particularized reasons. That what the trial court was probably trying to get at was that she found that this defendant was inappropriate and not ineligible. And I think that's backed up by what the trial court actually said in the transcript about the presumption having been overcome.
I'm sorry. Did you just say there was a nunc issued in this case?
Yes.
Thank you.
Yes.
Wanted to make sure I caught that correctly.
I'm not having gone back and fully looked at how we each wrote our statements of the case. I think it may have even been issued after this appeal was taken. So
Well, thank you if you have nothing else.
I do not, other than to rest on my brief and thank you. I understand I've exhausted my time, so thank you very much. I urge you to affirm.
Counsel for appellant?
Thank you. You know, there's plenty in the record about exactly what happened here. In fact, the judgment entry speaks very clearly, so it's very difficult for me to understand how that can be. It said, look, this is a conceptual, a trend. This is too technologically, or too much technology, or I'm sorry, too technical. Look, if a person is sick and has an addiction, that's what this is all about.
Counsel, but you seem to be making a policy argument, okay? Whether I agree with your policy argument or not, we have to look just what the legislature said, right?
That's
And
absolutely.
so if you look at the legislature, what they've said, in either statute, what is your argument there?
The argument in either one of those statutes is clear that a person who needs intervention should get intervention. And if it is denied under these reasons here, then it is an abuse of discretion. Now, more particularly, the state wants you to make a precedental decision here about retroactivity. This court has a clear opportunity to speak on intervention. There's not too many cases, if any. So what you say in this decision goes way far beyond Maxine. If you take a look at State v. Brooks, it was about the self-defense statute that says even at the time of the crime, you know, the law was then, but when you get to trial, then the new law applies. That's exactly what happened here. I think the most important thing that I would ask when you refine or come with your decision here is to say the priority in this time, in our times, is for treatment. It is not for the purpose of punishment. And the reason for that goes right behind the showcase. It is better for the individual, the community, and society as a whole, rather than to give somebody a felony conviction.
Thank you.
Thank you, Your Honor, for your attention on behalf of Maxine Sanders.
Thank you both for your presentations today. The court will take the matter under advisement, as you both know, since you're seasoned appellate attorneys. And we will issue an opinion that will be sent to both sides, as well as obviously you can review it online when it's issued there. Thank you again, and I hope you both have a wonderful day.
Thank you.